If a spouse dies without a will, doesn't the surviving spouse automatically get everything? Great question. You probably don't like to hear the answer, which is, it depends. So let's talk about that. What do I mean by that? Well, how long has the couple been married? If they live in Washington and they've been married for 50 years, likelihood is everything they have is community property. So you can have community property, which means your joint property. You can also have what's called separate property. We'll talk about that in a minute. If everything this couple has is community property, and if there is no will, the laws of intestacy, which are the laws of what happens when you don't have a will, say that everything goes to the surviving spouse. Will there need to be a probate? Probably not, because there'll be a lack of probate affidavit. Usually you can avoid probate in that scenario. What if instead that this couple has been married for 10 years and they have community property, and one spouse has some separate property and one spouse has separate property? Maybe they got an inheritance from their side of the family. Now what's going to happen? Well, when you move it away from the simple scenario of just community property, you've got community and separate, the laws of intestacy are different. And I'm not going to get into exactly how they are different, but I can tell you it gets complicated because you have to determine what's separate property. Heirs at law have to be determined, and then figure out, well, where does it go? And it's going to go through a probate. And it's the type of probate where you don't have a clear plan, then there's going to be more opportunity for people to argue about, well, no, that wasn't separate property, that was community. They commingled it, they made it community, on and on. Whenever you're talking about a fight in court, think legal fees, because litigation fees in a probate are where the expenses really can get run up.